Hello and welcome. I am Abhirup Dasgupta, a partner with HSA Advocates. Our topic for today is the Insolvency Resolution Process for FSPs in India. FSP is the acronym for Financial Service Providers. Most of you may be aware of the Corporate Insolvency Resolution Process of companies and how that works. But today's topic is more of a beginner's guide for all of you who want to have a lowdown on how the process works for FSPs. Of course, to begin with, what is a financial service provider? Simply put, FSPs are entities which provide financial service. This would include banks, financial institutions, NBFCs, etc. Now, when the IBC was first introduced in 2016, insolvency against FSPs was not permitted. But in 2019, the legislature removed this blanket protection and came out with something called the FSP rule. This is short for the Insolvency and Liquidation Proceedings of Financial Service Providers and Application to Adjudicating Authority rules of 2019. However, these rules have only been notified to NBFCs having an asset base of more than rupees 500 crores, which roughly translates to about $70 million. Now, coming back to the moot question, that is, what is the difference in the process as compared to the insolvency and liquidation of a normal corporate debtor? At the outset, the license of the FSP to carry on its business of providing financial service cannot be suspended during this process. While the insolvency of a corporate debtor can be initiated by either the corporate debtor itself or a financial creditor or an operational creditor, the insolvency of an FSP can only be initiated by the appointed regulator, which in this case is the Reserve Bank of India. Second, under this process, instead of an interim resolution professional, the RBI must nominate someone called an administrator, who, if appointed eventually by the NCLT, will have exactly the same rights and duties as the IRP. Third, an important aspect of the insolvency of FSPs is the applicability of moratorium. This becomes applicable as soon as a petition is filed and not on the admission of the petition. Moreover, the moratorium does not apply to third-party assets in the custody or possession of the FSP in the capacity of being a lender. So, if a mortgaged asset is in the custody of the FSP, despite the moratorium, the FSP is entitled to dispose of that asset to recover its legitimate due. Fourth, one of the most fundamental differences in this process is that a resolution applicant, which is someone who is likely to take over this FSP, must be already engaged in the business of providing financial service. So, just as an example, a real estate company or maybe a petroleum company cannot submit a resolution plan for an FSP. And unlike the insolvency of corporate debtors, for FSP, the consent of the RBI is mandatory for approving a resolution plan. Similarly, even if there is no successful resolution and the FSP eventually goes into liquidation, its license for providing financial service cannot be cancelled while this liquidation process is ongoing. As of now, this process has been successfully run for DHFL, the SRE companies, and Reliance Capital. But only time will tell whether this is a step in the right direction and whether these provisions need to be extended to banks and financial institutions. Thank you.